What it do, y'all? Hey, I'm back in the office, man. I had to bring y'all this, man. But I'm gonna catch y'all up on this situation. This is the Karen Reed trial, right? Where ain't no allege, where the police tried to frame this woman named Karen Reed. You heard me right. The police tried to frame this woman, tried to say that she hit her husband. That's how the tail light, a tail light, not no dents, nothing. She hit this man so hard, they saying that he got black eyes and dog bites on his arm. How can you hit somebody and they get dog bites on their arm and they get black eyes? So remind you, they got camera footage of one of the officers. He's an ATF agent named Higgins. He liked the woman Karen Reed, and this is her dude that they found dead on the police line. The police got rid of his dog that he had. They had a 6 years that was in their family. Why would the police all of a sudden get rid of their dog? This is a common sense trial to me. The man got dog bites on his arm. He was found on a police line. The police that's in the house, they never checked their crib or nothing. They got rid of their dog. Now they done sold the home that been in their family for generations. Not only that, this judge right here that y'all see on the screen, she's working with them. She's not allowing them to bring in nothing, right? But in this situation, it's probably like an 18-minute clip. This sidebar is because you ain't gonna believe this shit. Will somebody come look at this shit? They had a sidebar because the judge don't even want to let them cross-examine one of the Commonwealth witnesses. You heard me right, man. They don't want to let the defense cross one of the witnesses that's going to be on the stand. Now, where in the hell, why do we even got to have this discussion? You know, anybody get on that stand is going to get crossed by the defense. Anybody. That's just courtroom 101. That's just courtroom 101. Man, this is unbelievable right here, man. So I'm about to let y'all listen to this. They are about to discuss a situation to where the prosecutors, which is the Commonwealth, is going to have an expert up there, a so-called expert, but they don't want. They just saying we can put somebody up there and let them tell their story and can't nobody say nothing. I ain't never heard of this shit right here, man. They really trying to frame this woman. It's crazy. I was watching the Young Thug trial and I should have been tuned to this the whole time. This is a whole new retrial. This mug is serious. Let's get into this, though. I'm going to let y'all watch this.
So I want to talk a little bit more about what we talked about at Sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision, and I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate...
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shall...
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course a court is judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
Said CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor, in the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what...
In one area, right? One specific area?
Well, you can call it one
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source code.
They let him, they end up letting him cross her. And they killed her. But she is trying to tell them, y'all got to tell me everything. No, the hell they don't. What court, where is this at? Massachusetts, y'all wrong. You worried about what they gonna ask her when it's time for the cross. This shit is crazy. Y'all trying to limit them to what they can ask. Wow, this is so crazy.
That she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking me to allow.
If I could give you the answer, Your Honor, I will explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location.
They didn't allow it because the bitch, it was an opinion, you stupid ass dude. It sound like a fucking cartoon character, man. You see this shit? Like, why are they having, bro, they sent the jury away for this shit. The ask the defense, what are they gonna ask this lady? This is their witness. Don't worry about what we gonna ask her. Y'all using her and we got our information, we gonna crush her. They trying to keep it limited. Nah, the bitch erased the text while the man was out in the cold and said, tried to decode it and said, how long it take to die in the cold. House. That's how stupid they are, man. And you gonna sit up here and tell me, man, let me continue, man.
That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she's some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp would...
No, that was raised, but this... What was problematic in Maryland? The same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor,
okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom.
They so scared about what they got. You know what I mean? When they cross it, they so scared about the information because they already deemed her not liable in the last trial. You think we ain't about to cross her and beat her down again? You got life twisted, nigga. Both of y'all.
Paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them. In this case, it's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here is the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled, to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? But one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term Galbertize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So
my bad. That's it. That's all, man. Y'all can't limit him to what he want to say. Tell this woman. This is crazy. And they found out the judge is related to somebody in this case. She would not get out. They tried to recuse her. She would not leave, dog. That let you know, hey man, y'all go tune into this case, man. Y'all, hey, trust me, it's like a movie, man. Y'all will not be mad. Like, it's deep. They really tried to frame this woman, man. Ain't no alleged. They tried to frame this woman. And they locked up one of the YouTube dudes, Turtle Boy, because he been getting deep into this shit. But hey, y'all know what it is with me, man. Hey, subscribe to the channel, leave your comments, all that, man. It's 1942. I'm out.